Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In this episode of the Labour Justice Barometer, we're going to be talking about the amendments to the Employment Equity Act, which was signed into the law in 2023, and it will come into effect in January 2025. Now, I'm going to give you a summary of the material amendments to the EEA. I can't go into full detail, but as always, we will leave a link in the description box for you to read this for yourself. But this summary is mainly to give you a bit of context for Debbie and I's discussion. Now, the first change, the definition of designated employer. A designated employer is currently an employer with more than 50 employees, or which has a turnover in excess of the prescribed turnover threshold for the sector in which the employer operates. Now, the amendments have the effect of removing the turnover threshold so that only employers with more than 50 employees will be regarded as designated employers for the purposes of the EEA. Now, this means that employers with less than 50 employees will not need to comply with the affirmative action provisions in the EEA and will accordingly not need to have an employment equity plan in place and to submit employment equity reports. The Minister of Employment and Labour has also been empowered to set sectoral numerical targets by way of regulations to ensure equitable representations of people from designated groups. Now, who are our designated groups? African, coloured and Indian people, women, people with disabilities at all occupational levels. The numerical targets will obviously differ according to sector, about 18 or so, and occupational levels. And while there have been draft regulations to the effect, these regulations have not yet come into effect, and so it remains to be seen. But an amendment to Section 20 has also been made. Now, this is in relation to employment equity plans, and this links the sectoral numerical targets prescribed by the government to the numerical targets that must be set by a designated employer in its equity plan. So this will be a significant change, as currently an employer sets its own numerical targets based on the demographics of the country or province in which it operates. Another change to designated employers will also be about certificates of compliance. So going forward, designated employers will also only be able to obtain a certificate of compliance to do work for government if they have met the applicable sectoral targets or they have a reasonable ground for non-compliance, and provided that there's been no complaints of unfair discrimination in relation to the employer. Another change has also been the definition of people with disabilities has been amended, and this will actually include people who have long-term or recurring physical, mental, intellectual, or sensory impairment, which in interaction with various barriers may substantially limit their prospects of entry or advancement. A few other changes which we won't be diving into too much detail, but there's no longer a requirement for the Health Professionals Councils of South Africa to certify psychological testing and similar assessments. Labour inspectors have been given the authority to request a written undertaking from designated employers to, amongst others, consult with employees, conduct an analysis and publish reports, and assign responsibilities to one or more senior managers. The minister has also been empowered to make regulations regarding the manner of service of compliance orders. And Section 21 has also been amended to remove the specific date for annual submissions of employment equity reports, and the minister is now empowered to make regulations dealing with the requirements of employers for submitting their employment equity reports and the timing of these submissions. And furthermore, actually going forward, designated employers will no longer be required to submit the income differential statements to the Employment Conditions Commission. The final one that I'll just briefly touch on is Section 16 of the EEA has also been amended to clarify where there is a representative trade union in workplace, a designated employer is only required to consult with the union and not with its employees in circumstances where consultation is required. So the Equity Amendment Act actually introduces significant changes to the Employment Equity Act. And I mean, Debbie, you've written articles on this, and we will definitely leave the links in our description box. But what are your initial thoughts on these changes? Is it welcomed?
So I think employers will probably be embracing the idea of sectoral targets, and particularly the second set of amendments. There were amendments that were published in 2023 that were problematic, and then amendments which were published in 2024, which speak about designated groups in a way that is probably simpler to interpret and to implement. The idea of sectoral targets probably permits the sector itself to have a bit more influence in terms of the setting of targets. The amendments and the regulations could have a positive impact if they are received in the manner and spirit in which they were intended, which is that of the Act, which is to transform the demographics as an aspect of transformation. If we leave transforming our economy up to an Employment Equity Act that will fall short of the mark, it can have a very limited impact because it is only seeking to achieve redress within a small part of the economy, which is the formal economy, formal employment, employers who are considered to be designated employers. So it's not the answer to our inequality problem. It's one small piece of that puzzle. And I think its reception and impact will really largely depend on how well it is perceived by employers. And the sectoral approach, in my view, is a step in the right direction towards a more coherent rather than a fragmented approach in which each employer is left to their own devices.
I want to go back to this whole idea of sectoral target. These are, according to Section 15A of this Amendment Act, it allows the minister, after consultation, to identify specific national economic sectors and to set numerical employment equity targets for each sector. So this is also coupled with the definition of sector. This is why I think when it comes to sectoral targets, it just requires the designated employers to align their figures with industry-specific benchmarks. So taking that into account and knowing what this might bring, what challenges or opportunities do you foresee for businesses trying to meet these targets?
Well, the opportunities obviously is in meeting the targets. Employers will qualify for, or at least receive certification to be able to do business with the state. So it is the creating an incentive for transforming one's workplace. Of course, the challenge is if implementing the targets is a tick box exercise and simply one of compliance and not genuinely seeking to transform and ensure that a workplace is reflective of our country's demographics. Look, the first set of amendments to the regulations and the first targets that were set were problematic in the sense that there was incoherence in terms of the numbers. The disaggregation into population groups was problematic within some of the sectors, as well as the gender breakdown. And I think the 2024 regulations are a lot more nuanced and have been designed in conversation with sectors. I think if there's been participation in the formulation of sector targets, then it shouldn't be too much of a challenge. Businesses may have been structured in a way that is not inclusive, either on the basis of gender or on the basis of race. And those are the employers that will have more of a challenge in meeting the targets. There are, as you've mentioned, Aisha, there are 18 sectors and targets for 18 sectors. So it is representative of our economy as a whole, ranging from agriculture to education to public administration, hospitality, wholesale and retail. I think some employers are obviously going to struggle more than others. The consequences of non-compliance. It remains to be seen the extent to which the Department of Labour will be policing or sending inspectors into workplaces and what the consequences will be. Obviously, non-compliance will disqualify an employer for state contracting, which for some employers may not necessarily be an incentive, but for others will be an incentive. So I think it really will be a mixed bag in terms of the extent to which businesses will comply. Of course, if the Department of Employment and Labour does become more nuanced in its inspections and issuing of fines or seeking undertakings to comply, we may see a lot more dissatisfaction with the targets that have been set.
I like what you said about it being a tick box, that risk of a tick box compliance where you're just focusing on, meeting the targets rather than actually addressing meaningful inclusion. So I think it'll be interesting to see how employers will actually balance, these goals of operational realities and then at the same time balancing transformation goals through these sectoral targets. Now, one of the other changes that was mentioned, there have been a number of definition changes. So the first one was the change to the definition of disability and designated employer proposed by this Amendment Act. What do you think about these definitions, Debbie? Do you think that these definitions have actually hit the nail on the head, or
the definitional changes with persons with disabilities? This really is required in terms of our international law commitments. We are a signatory, and in fact I think it was 2007 that we signed on to the Convention on the Rights of Persons with Disabilities, and it's taken us a long time to get to the point of ratifying and implementing those commitments in law. So this would meet one of those commitments, and I think it's a very helpful amendment in terms of clarifying the extent to which persons with disabilities is more inclusive, all forms of disability, but also, in saying that we need to recognize that disability is not so much about the impairment itself, but the extent to which an impairment becomes a barrier to a person from either entering into employment or advancing in employment. The international position is shifting away from this medical model of having an impairment that classifies as a disability to rather assessing a person's ability to advance in employment. What the amended definition does do is it introduces the element of intellectual and sensory impairments and this idea of interactions with barriers that limit advancement. And that being more of the social model rather than the medical model. And then in terms of designated employers, I think the goal here is to simplify which employers are bound by Chapter 3 of the Employment Equity Act, which employers are required to implement affirmative action measures, and doing away with voluntary compliance. Of course, voluntary compliance can be pursued by an employer who's not a designated employer, but then they wouldn't be able to use the framework in the way that a designated employer must in terms of reporting, for example.
I think just to speak to what you mentioned about the definition of disabilities, and if anyone was actually listening to our last episode, we spoke about disability and discrimination. And I think one thing we mentioned is obviously this whole idea of reasonable accommodation. So what you mentioned here, Debbie, about how, it's a positive step forward in the sense that we've actually met the international standards of requirement. My concern around that is, how will employers be able to actually reasonably accommodate this? Because at the moment, like you said, it's not the barrier to, it's more of that obstacle of how can you actually accommodate current employees with diverse disabilities. So that would be my concern around this is, I think more needs to be done in terms of how employers are reasonably accommodating, because yes, we are changing our definitions in a more progressive way, but I think there needs to be more tools or resources provided for employers, particularly when it comes to a role in how we accommodate diverse disabilities. But I do agree it is a very positive step forward in meeting international standards. And in terms of designated employers, I think they are. It obviously reduces that administrative burden.
So certainly that was the intent, Aisha, was to reduce that burden on employers and employers who are genuinely seeking to comply. I would think this new approach should take some of the burden in any event, even if you are required to comply, off of the employer, knowing that sector-specific institutions can feed into the process, so employers are not having to repeat the exercise in their own individual workplaces, but rather to seek to comply with a sector-specific target. Just to come back to the reasonable accommodation context, I mean, I think this may well have been a missed opportunity. Reasonable accommodation in the Employment Equity Act currently, although it appears in the Code of Good Practice on persons with disabilities, in Chapter 3, which is the affirmative action provisions, which we're talking about designated employers. So it appears to narrow the scope, which is problematic. And I don't think our case law has assisted with that. So we're seeing a reasonable accommodation as an aspect of affirmative action, whereas it should in itself be a standalone principle of our non-discrimination law. And how we implement that in the workplace, we do have technical guidelines for persons with disabilities, and I'm sure there's an industry of occupational specialists. I think we're not putting all of those pieces together yet, and there's work to be done. Whether or not we need a legal framework for that is another question. I think if employers could achieve the objectives and the revised targets in the 2024 regulations separate out persons with disabilities, and in most sectors, occupational levels, impose a 2% target on employers. They're not lumped together with other designated groups, and with the recognition that reasonable accommodation is part of that exercise. But I think you're absolutely correct. We do need to have more guidance, or at least to properly implement what does exist in our code and in our technical guidelines. And I think our jurisprudence could provide better clarity there.
You're listening to the Labour Justice Barometer, and we'll be right back. But Debbie, you actually wrote about the amendment bill a couple of years ago, and you use this term "kicking the can down the road," which is it's not a new term, but I mean, I love the way you put it in the actual article. Do you think these changes address systemic barriers to equity in South Africa, or are we at risk of kicking the can down the road with these new amendments?
Yeah, actually, I think we're always going to be kicking the can down the road with this. It's a question of how much we achieve while we're still kicking the can down the road. Our Employment Equity Act can only achieve so much. We know we have a very high unemployment rate in South Africa. So if we really want to address systemic barriers, we've got to address other issues in our education system, in our spatial apartheid. We still have seats of the economy sitting in very different places spatially to where persons who have been disadvantaged in the past reside. So we place all sorts of barriers that we haven't addressed. It certainly is a tool that we have. It's better than not having a tool to try to address the barriers in the workplace. But in some ways, there are more vulnerable groups that we've missed entirely because we've limited the scope and reach. We've looked at, designated groups. Gender, obviously, sex and gender is globally one of the grounds on which redress is required, and persons with disabilities. But in terms of race, we've used our apartheid classifications. We've focused designating people in the same way that the apartheid government did, which really, for me and internationally, this has raised questions around genuine compliance, with the international standards around indigenous communities, which in South Africa would be the Khoisan San people. We've lumped them in a categorization. The point about redress and affirmative action, and certainly South Africa's substantive equality position is to address things like stigma and objectification. And here we are placing a label on people who are very unwilling, and for very good reason, to accept that label. That's an issue we have not addressed, and it has been flagged in international law spaces. Foreign nationals, we also have a way to go in terms of how we treat persons who are not South African, but may, for many other reasons, quite apart from being persons who are workers in South Africa, but may well be members of disadvantaged communities in other aspects. And I think we still have a way to go to implement our obligations and to show due regard for persons with disabilities. So yes, in some way we're kicking the can down the road, but we are building the system that can help us, I think, and has helped us, perhaps not as quickly as we would have liked, but does go some way to transform our workplaces.
What you said, yeah, it's hit the nail on the head, essentially. I think when I first looked at it, and I thought, okay, so yeah, when the first amendments came out and the first, everyone was talking about these sectoral targets and how it's kind of reinforcing structural barriers, and people are now going to be focusing more on quotas and meeting them instead of actually addressing root causes. So I think like some of the things that you did mention in your article, skills development, career progression, unequal access to education, these are some of the things that I think could just be additional considerations as well to look at when it comes to progressing the Amendment Act, and obviously looking forward and how we're going to view the EEA as well. Our last question that we always ask, I now have to reframe it because it's not about a case. It's something, it's obviously in a lot more different setting as we talk about the EEA. But from a labor justice perspective, you have mentioned, looking at marginalized groups in particular and how, these amendments can better align with South Africa's goal of decent work. Tell me more about that. From a labor justice perspective, how can these amendments better align with that?
That's a big question, and it would require us to take a step back. Of course, one of our biggest exclusions from the Employment Equity Act are those workers who are not employees, and the extent to which they are protected from acts of discrimination. That would bring in our equality law framework more broadly and the PAPUDA Act. And there we are not progressing nearly as quickly or as effectively or in a nuanced way to the extent that we are in the context of workers who are employees. So if we take, for example, harassment as a form of discrimination, we accept that. And the ILO's Convention 190, which is the most recent convention from the ILO, it's intended to protect all workers in the informal economy, workers in employment. And we have a sophisticated machinery, we have sophisticated legislation for workers who are employees. We have a good suite of protection, and we were able to implement Convention 190 through amending the Code of Good Practice on harassment. But I'm not convinced that we're doing enough to align with the goals of decent work, particularly for marginalized groups, being workers who are not employees. We haven't done enough to provide mechanisms for protection from discrimination. When I say discrimination, that might not even be the goal, but rather it's a very small part of a broader goal of protecting those workers from violence, harassment, and ensuring that that the tenets of decent work are taken seriously when we regulate for workers, and that we're not just regulating for workers who are employees.
So I think overall, like we've said, that there's still more to grow from this. I think would you agree with me to say that even though we've met some things here, I don't know if we're going to have to see how this plays out as well and how this is going to be enforced. And like you said, whether the Department of Labor is actually going to have these labor inspectors coming in, how are they going to actually ensure compliance? That's going to be the biggest thing. And also looking at these gaps, for example, the marginalized groups that you mentioned, Khoisan San, foreign workers, these are all aspects which I think we're going to have to see develop over time as well. I think we've just looked at, certain significant changes and the challenges and opportunities that it really does present for achieving, true labor justice in South Africa. There's more to do. The work still doesn't stop. There's definitely more to do. And I'm hoping the path to equity is more than just meeting quotas. I think it's about creating meaningful inclusion, which needs to continue on. But I do want to thank you, Debbie. I know you're not well, so I really do appreciate you coming on the episode and actually speaking to all of this. I think from both Debbie and I can definitely say happy holidays to everybody who's listening. We will leave all the links to the Amendment Act that we can find. Of course, the Amendment Act is only going to be enforced from the 1st of January, and we will update that link as well. But we will see you in our next episode, which will actually be in 2025, Debbie. That's exciting.
Indeed, Aisha, yes. Thank you for that reminder. And when you say the amendment will only kick in the 1st of January, that's just around the corner. So thank you, Aisha, and I look forward to speaking to you again soon.
This podcast is not intended to constitute legal advice.